federal district court decision that may help you if you applied for an EB-1A visa and it was denied. My name is Priya Alighieri. I'm an immigration attorney, and my law firm represents engineers applying for their EB-1A visa. So this decision came out maybe about 2 weeks ago, and it came out of the federal district court in Nebraska, and that's important, and I'll bring that up in a minute. But this decision is on the EB-1A, and it's specifically on the final merits analysis. So if you've been, I don't know, following me or reading about how the Immigration Service evaluates EB-1A visas, it's a two-step process, right? The first step is clearly written, outlined in the regs and the policy manual. And that first step is you have to meet a minimum of 3 out of the 10 criteria. I won't go into all of that analysis now, but that is the first step that the immigration officer is supposed to take. It's evaluating whether you meet the 3 criteria. And then the immigration officer is supposed to move on to the second step. And this second step has been problematic really since 2010, when this second step was introduced into the EB-1A process. So the second step is called the final merits determination. And again, very briefly, this second step, the final merits determination, is when the immigration officer, after he or she has decided you've met at least 3 of the regulatory criteria, the immigration officer then will look at your total evidence and decide whether it shows, in his or her opinion, that you have reached the top of your field. So it's subjective, to say the least, right? And also there's just really no guidance. There's no really requirements that the officer has to follow, or that's even explained anywhere. So, all we know is that the decision takes into account the totality of the circumstances. Okay, so if you've watched my previous videos, you probably would know that this is where quality matters. I don't want to go into that today, but quality matters. And I say that a lot, and that's mostly for the final merits determination. So going back to our case, so since 2010, the immigration legal community has been trying to remove this final merits analysis, the second step, because it kind of came out of nowhere. It came out in a decision, in like a footnote of a decision, and then now the Immigration Service has decided to apply it to all EB-1A visa cases. So we've been battling to remove it. And the good news is, finally, a federal district court a few weeks ago issued a decision clearly saying that this second step, this final merits determination, is unlawful. This federal district court, decided that USCIS is unlawfully adopting this second step. So let's play it out. So let's just say you filed, your EB-1A visa. Maybe you got an RFE. You file your response to the RFE, and then you get a decision. It's a denial, but the denial says that you meet, what, maybe three, four, or five of the criteria you applied with, which is great, right? But then if you keep reading, they end up denying your application because you don't meet the final merits. And again, who knows how the immigration service or the officer is applying this final merits evaluation. There's really no guidance. There's no criteria, requirements, anything like that that we can follow. It's just a subjective decision on the part of the officer. Good news is this federal district court found that this extra layer of review, this second step, is unlawful. I won't go through all the legal, like the legal specifics of it. But basically, in short, what this court said is that this new, this requirement, the final merits requirement, did not follow the proper legal process to be applied. So basically, they're saying the immigration service is unlawfully applying the second step. There's a certain procedure that has to be followed when you want to change, amend, add, rules, requirements to the law. Uh, you can't just all of a sudden decide, oh, we're going to take this little footnote and turn it into a requirement. So that's a good news, because we've been seeing final merit denials based on final merits a lot. And as I mentioned, the immigration lawyers have been trying to fight and get this overturned. But the reason, I'm very excited about this. I'm very encouraged by this, but this decision came out of Nebraska. And that's important because anyone outside of Nebraska, like, or any court outside of Nebraska or the immigration service on cases that are outside of Nebraska do not have to follow this ruling. So if you're in Nebraska, if you bring a case in Nebraska, that's great. You can rely on this ruling. But anyone outside of Nebraska, it's worth mentioning. It's worth noting that the court in Nebraska found this. We definitely will, in all our filings, we will reference it, even though we're in California. I did want to mention that it's not binding. It's not binding on the immigration service. It's not binding on courts outside of Nebraska. Let's talk about like very briefly, like maybe the facts of this case, and why it could benefit you to appeal or litigate. Like this case involved a journalist who met, I think the immigration service said that she met 5 of the criteria, right? Half of the criteria, and then decided at the end that she, didn't meet the final merits. And then they brought the case to federal district court, and we got this ruling. So what I also wanted to point out about the ruling is that typically, in my experience, district courts will not overturn an immigration service decision. And what do I mean by overturn? Overturn meaning if you bring a case to federal district court and they agree with you, let's just say the judge agrees with you, that judge usually will send it back to the immigration service and say, oh, you need to reevaluate based on blah blah blah. So when you send something back to the immigration service for reevaluation, like, you never know, you really don't know what's going to happen. So they could issue another RFE, they could, like, deny it again. It's just like the federal district court has seen some enough there to send it back. But in this decision, which is really amazing, is they overturned the denial. We don't see that very often. So the federal district court decided that this final marriage determination step is just unlawful, and then sent it back to the USCIS and said, I'm overruling your denial. You've got to approve this case. So, yeah, it's a great case. I will still keep you updated on what's happening, since this case, how cases are being adjudicated. But always keep in mind that you still have to have strong evidence, right? You still have to really have quality evidence. Even if that second step is unlawful, all the evidence provided to meet the criteria, it has to be high quality, has to be strong. But if you have any questions or concerns, please contact my office. I would be happy to review your case, maybe review your denial, and see what steps we can take from there. Thank you for watching. Subscribe, and I'll see you next time. Bye.